continue. Okay, I just pressed continue. Welcome. Before we get started, I wanted to just talk about a little of the logistics of this Zoom webinar. There is a chat option when you're in Zoom. So if you want to ask a question during this hour we have together, you can either just unmute and ask verbally, or you can chat the question. I have the chats up here on my screen. If you wanted to just kind of practice right now, you can look at the chat by just going to the button that says chat or more, and it will pop up the text box. And I cut and pasted a link in there that you'll see. That's just a link to the evaluation that you can fill out after this webinar to give me some feedback. So let's get started. Today, thank you to the Hawaii Community Federal Credit Union. Education is a really important part of our firm. And so we love to have the opportunity to help educate our community. So today, what are we talking about? When we're talking about estate planning, I kind of like to start on a light note. Specifically, there is a cartoon strip for Snoopy and Charlie Brown. And so Charlie Brown says, someday, they're sitting there on a lake looking out at the horizon, and he says, someday we will all die, Snoopy. And Snoopy looks at Charlie Brown and says, yes, but on all the other days, we live. Because nobody likes talking about death, nobody likes thinking about death, but today for estate planning, we're being proactive and we're focusing on living your life with peace of mind because you've taken care of your estate planning proactively. I am John Roth. I'm an estate planning attorney. I'm originally from Oahu. I've been on the Big Island now for about 12 years. I went to UH Law School. I went to Punahou High School. Our firm, let me see, there we go, is myself. And then Kumu Belcher, he's the taller guy on the left. He is in our Hilo office. And then there's Crystal right there, who is our office assistant. And then my dad is right there, who is of counsel. And so the four of us make up Hawaii Trust and Estate Counsel, and we're an estate planning law firm. And today, that's what we're going to discuss. Estate planning is basically making sure your wishes are carried out in the event of your incapacity or death. We're going to discuss that process, thinking about, do I need an estate plan, to actually having one, what's included in that process? And then what are the basic documents that are part of an estate plan? And then we use hypothetical scenarios because it's easier to understand the documents when we're talking about hypothetical scenarios to explain the different issues that come up. And then when to update your estate plan, which is a very important part of estate planning. So basically the definition here, like I said, is a proactive process to put together a plan to make sure that your wishes are carried out in the event of your incapacity or death. I bold some of these words, proactive. It's important because you need to be able to put together a plan. You have to have capacity to make sure that your wishes are carried out. So the more proactive you can be, the better. If there's any medical emergency going on or capacity is questionable, the conversation can be a lot more emotional, difficult, or maybe even impossible. And then I also bold and underline incapacity, because estate planning, we a lot of times think about where should my stuff go when I die? And that is an important part of estate planning, but just as important is, what if I'm living but unable to manage my own affairs? An estate plan can help facilitate that type of caretaker relationship if someone needs to step in during your life while you're living to help you manage your own affairs, pay bills, sign contracts. So the basic documents, which I'll briefly go over, include the will, a disposition of remains, a trust if needed. And today when I use the word trust, unless I say otherwise, we are talking about a revocable living trust. a power of attorney, advanced healthcare directive, and a HIPAA privacy release. So a lot of times people will call my office and they'll say, I need the best estate plan. I need all those documents. And I'm like, wait, hold on a second. There's no such thing as the best estate plan. Estate planning is not a one-size-fits-all proposition. The way I define the best estate plan is what's chosen by an informed person. So we are, as estate planning attorneys, responsible to help people make educated decisions. We are educators, first and foremost. And then it's based on a current life snapshot. During the process, we make sure the plan, incorporates hypothetical scenarios of things that could happen in the future, but it has to be based on what's happening in your life right now. It's easy during our conversation about estate planning to say, okay, well, I want this to happen now, and in 5 years, I want this to happen, and in 10 years, my kids will be in college, and then I'll retire, and then I want this to happen. And I'm like, yeah, that's great. I totally advocate proactive planning as an estate planning attorney, but the estate plan has to be based on right now. What do you want to have happen to your affair, to your stuff, if you became incapacitated or died yesterday? Congratulations, you've already survived yesterday. But if not, what would you want to have happen right now? And then as your life, family, assets evolve over time, so can your estate plan with you. You need to keep it amended and current. And then ultimately, what provides you peace of mind? Peace of mind is the goal. We are all after peace of mind. But there are lots of different ways to get to peace of mind. Everyone has their own path, and ultimately the plan that you end up with is ultimately the goal is to give you peace of mind. A lot of people have different priorities, goals when putting together an estate plan. And so really it's just unique to your situation. During the first estate planning consultation, I like to explain what you would need to have a productive initial consultation, because there are a lot of roadblocks to doing estate planning. And one of them, people come up, no one wants to talk about death in their estate planning. And so they say, oh, I'm not ready. I haven't decided this. I haven't decided that. I don't have all my information gathered. So I like to just say what information that you should have gathered prior to meeting with an estate planning attorney to discuss your goals and concerns. So first of all, have a pretty good idea of what your goals are. Think about those things. Sometimes I'll sit down with a potential client and we'd be talking about their estate planning. And then I'll say, okay, so what if you died? Who do you want to be blank? And they'll say, oh, I never thought about that. I'm like, well, hopefully you'll think about these things ahead. So the first initial consultation would be very productive. So to think about your goals. Who do you want to act on your behalf to carry out your wishes, do your finances or your healthcare? They can be different people in different roles. And then where you want your stuff to go. Generally, who do you want your beneficiaries to be? When you're meeting with a professional, we will help you brainstorm. That's one of the benefits of using an estate planning attorney, is that during the meeting, we bring up questions and we make sure that you've addressed all of the potential scenarios that you may not think about. So when you're thinking about your goals, it's always good to have alternates in place. And so we always ask those questions. Okay, if that person's not around or is unable to serve, who the backup would be? And that sometimes will stump people. They don't have a backup. So just kind of be thinking about that ahead of time. And then what does your family look like? That's usually really basic. Who's your next of kin? Do you have children, their names? And then what do you own? You don't have to have bank account numbers or specific balances, but generally, what type of assets do you own? How are they titled? Are they separate or are they joint? Do they have a designated beneficiary? And approximately what is the value? You don't need to get an appraisal or anything. Just kind of generally know approximately what is the value, how are things titled, and if there's a designated beneficiary, who's the designated beneficiary? So with that information, you can really have a productive initial consultation. So I throw around words when I talk about estate planning, And to me, I use the words all the time. So if I ever use a word that you don't know, please just ask a question, say, excuse me, I don't understand that term. Probate's one of those terms that come up a lot during estate planning because everyone says a lot of times, I want to avoid probate. And so to have conversations about what that means, you have to first understand what probate is. And so if someone dies and has certain assets, then the state of Hawaii, if they die here, says, hey, we want to be involved. We are interested in what's happening because the person who died owned either real estate or liquid assets that total $100,000 or more, financial assets that total $100,000 or more. So if someone dies and they own real estate in the state of Hawaii, probate's actually triggered in each state where you own real estate. So the more states more properties you own in different states, the more advantageous it becomes to avoid probate. And timeshares do count as real estate that do trigger probate because timeshares do have a deed that's recorded in the state. And then also I have a little note that says rights of survivorship and designated beneficiaries. Those will bypass probate. So if two people own a piece of real estate, if they're husband and wife, which is tenants by the entirety, or if joint tenants with rights of survivorship, then when one person dies, the other joint owner just automatically becomes the owner. There's no probate trigger. That by rights of survivorship just bypasses that probate process. And so do designated beneficiary provisions. So those are two very important parts of an estate plan. It's not just the documents, it's how you hold title to assets and how you utilize designated beneficiary provisions. So if probate is triggered, there is a process and the process requires that if there's a will, let's just say there's a will that appoints this child to be the personal representative or the executor of the estate. That child calls my office and says, oh, my mom just died. She was a widow and now they own their home. They have a will that says I'm the personal representative and me and my siblings are the beneficiaries. And I say, okay, so she just had a will. The property's in her individual name. There's nobody else on the property now. She's the last surviving owner. And that means we have to go through the probate process. So I say, okay, bring your mom's original will in, bring in her death certificate. We'll put together an application that we send those documents off with more information to the courthouse in Hilo, if the property is located here on the Big Island. And the registrar's office, the courts, they review the application. Hopefully they approve it. And then they send documents back approved. And so that process generally takes a few months and can cost like about $5,000. And so some people will want to avoid going through that probate process. There is a question right here on the chat. It says that my brother's house in Hawaii will go in probate and he needs a trust. The house in Hawaii is only in his wife's name and she passed away in January. Can probate and trust happen at the same time? So I don't fully understand every aspect of this question, but if the wife was the only name on the deed and she died, probate will be required to transfer that property out of her name to the appropriate beneficiaries. If she had a will, the beneficiaries will be named in her will. If she doesn't have a will, then there's a set of rules that apply when you don't have a will that says where your property goes if it doesn't go to anyone through rights of survivorship or designated beneficiary provisions. And so if the brother who maybe is inheriting the property wants to now hold the property in his own revocable living trust, he can create that revocable living trust and then transfer the property from his deceased spouse into his revocable living trust instead of just into his individual name. And we'll talk about that in much more detail when I go into trusts. So in this case, maybe there was no will. And so the rules that apply are called intestate succession. You still go through the same probate process, but there are a set of guideline rules that say where stuff goes if there is no will. And so they look at whether the person's married, whether they have children, whether they have children between just the spouse who's surviving or a different person. And so you just have to look at what the intestate succession laws say in terms of where that property will go now. Okay. And then, yeah, just that probate process, the person who's nominated in the will as a personal representative can't do anything until they get those documents approved by the state of Hawaii. So first of all, before we get into the specifics regarding the basic estate planning documents that I went over earlier, we'll talk about is sometimes referred to as will substitutes. So like I said, yeah, in your will, you can say who gets what, but rights of survivorship will control where stuff goes. For example, rights of survivorship is if two people own a joint bank account and one person dies, the other joint owner just automatically becomes the owner through rights of survivorship. And so joint bank accounts are always like that. Real estate sometimes has rights of survivorship. You just have to look at the deed. But so basically rights of survivorship means, let's say I have a client, she's a widow, she has 3 kids, and she in her will says, I want everything to go to my 3 kids in equal shares when I die. But then I talk to her more. I'm going through the interview sheet. I'm saying, okay, what do you have in the bank? She, and they say, oh, I have $100,000 in my bank account. But since this one of my children helps take care of me, they're joint on the account with me. And I'm like, okay, so you have one child is joint with you, but when you die, you want everything to go to your 3 kids in equal shares. And the client says, yes. And so I say, okay, well, you understand that that joint bank account has rights of survivorship, and that will control, not the will. So if that $100,000 you want to be divided in 3 equal shares when you die, it cannot be joint with one child, because if it remains joint with that one child and my client dies, that child through rights of survivorship becomes 100% owner of that account, even though the will says she wanted everything to go in 3 equal shares. So you really have to incorporate rights of survivorship into the plan if you want to make sure your assets go to the way you want them to be distributed after your lifetime. And then designated beneficiaries is the same thing. It will control, not the will. So for accounts like life insurance or retirement accounts where you're always naming designated beneficiaries, if you in your will says, I want everything to go to my 3 equal kids in equal shares, but maybe on your designated beneficiary, when you first started your job, your retirement account started getting funded, how many years ago, you put your sibling maybe as the designated beneficiary because maybe you didn't have any kids at that time or something like that. So that when you die, even though your will says everything goes to your 3 kids, if your designated beneficiary still has your sibling maybe from years ago that you put in when you started that account, your sibling will inherit that account. So you really have to make sure when you're doing estate planning that you review and, if necessary, update the designated beneficiary provisions to make sure that they're current with your current set of goals. Okay, so you really have to understand rights of survivorship and designated beneficiary provisions because they will control those specific assets. So they have to be aligned with how your estate planning documents work to make sure your goals are carried out. I have one more question here, and it says how to get my name on a deed. My wife passed away 6 months ago, and I wasn't on the deed. I'm paying the mortgage. So if, again, it's kind of similar to the first question, if someone dies and they're the only one on the deed, it triggers probate. And if there's a will, the will say where that property should go. If there is no will, there's intestate succession that will look at your marital status, your children, and then tell you what they think you would want. Sometimes intestate succession is exactly what you want. Sometimes it's different. So you really just have to look at what the rules say so you make sure you do it correctly. Okay, so look, getting into the basic documents. I like this kind of chart because it shows what documents are used after death, what documents are used during life. The during life ones are kind of like the incapacity planning, where you're living, but you can't make your own decisions. Those documents are used to help somebody carry out your wishes, make decisions for you. So after your death is the will, disposition of remains. Used during your life is the power of attorney, advanced healthcare directive, HIPAA release, and then a trust, the revocable living trust, is kind of a hybrid. You work with it during your life and then also after. So we'll start by going over the will. The will is the basic document that everyone kind of thinks of when they talk about, when they discuss estate planning, because it says where your stuff goes when you die, who the executor or personal representative is, to carry out your wishes. If you have minor children, you can name the guardian of your children to physically care for them, or a conservator to take care of their funds. And then if you have a trust, you also have a will, and it's referred to as a pour over will that just says everything goes to your trust when you die. And the trust has all the designated beneficiary provisions. And so basically a will just lets you control who's in charge and where your stuff goes. And if you don't have a will, you go through the intestate succession, which I refer on this slide. Kind of a funny word. And then I also in Hawaii, to be a valid will, it has to be witnessed by 2 people. And unless it's a holographic will, which is a will that's written in the handwriting of the person who's deceased and signed by them. It doesn't need to be witnessed, but it does need to be in their handwriting and signed. And that's a holographic will. So then in the other document is disposition of remains, and that just makes it clear whether you want to be cremated or buried and who carries out those wishes. So again, these documents, sometimes people say, oh, everyone knows what I want, and sometimes they do and sometimes they don't. So it just makes it very clear, because the best estate plan, yes, gives you peace of mind that your wishes will be carried out, but also will minimize the potential disharmony among your loved ones that you leave behind. So the more clear you can be, the less arguments, hopefully, that will be created after your lifetime when everyone's trying to figure out what to do. So I like to make it very clear and say whether you want to be cremated or buried, who carries that out. If you have specific wishes beyond that, you can talk to your family, you can write it down. That's what people mostly do. And then the power of attorney document. This is the document that will appoint someone who can act on your behalf during your lifetime. So this document, and sometimes people will call me and say, I need to be my mom's power of attorney. And so can we do that? I'm like, okay, well, your mom's the one who would appoint you. So can you put her on the phone? We can schedule a meeting. She can come in, we can discuss it. And sometimes it's, she's not doing very well and she can't really communicate that well. And can I just do it for her? And I'm like, sorry, it's too late maybe at that point, because if your mom isn't able to make decisions on her own and communicate those decisions, then she can't appoint you as her power of attorney. So it kind of goes back to being proactive. You need to be proactive, so you make these decisions and you appoint who you want to make decisions on your behalf if you're living but unable to manage your affairs. So if you don't have a power of attorney document, and you, in this case, the daughter who calls and says, I want to set it up for my mom because she can't make decisions on her own right now, then I say, I'm sorry, it's too late. And you have to go to the court and be appointed her legal guardian or conservator to act on her behalf, which is more expensive, time consuming, and public. And so we try to avoid our clients having to go through legal guardianships or conservatorships. And then there's the advanced healthcare directive. So power of attorney is everything other than healthcare. And the Advanced Healthcare Directive is just healthcare, and it also lets you make decisions in advance, like whether you want to be on life support or not, whether you want to be an organ donor. And so there are some key decisions that you can make in advance so that your loved ones, if you're in the hospital and you can't communicate on your own, would be able to know what you want and step into your shoes and be your healthcare representative and help carry out your wishes. So there's less of a burden for them to have to make their own decisions and try to guess what you would want. It's never an easy decision to make, but it's easier for the family when there is some direction. And I'd just like to point out that the Advanced Healthcare Directive is not a POST. As a lot of times people refer to it as a DNR, a do not resuscitate. That is not what an Advanced Healthcare Directive is. If you do want a DNR, a do not resuscitate, or in Hawaii it's the POST, P-O-L-S-T, you would do that with your physician in addition to the Advanced Healthcare Directive. And on that document, you can say more specifically, I do not want to be resuscitated, or I don't want specific treatments. And then your physician would sign that, and it becomes a physician's order that would have to be followed. So it's for the POST or the DNR, that is for people who are more close to death, who are concerned about not wanting to be resuscitated. The Advanced Healthcare Directive is you've been resuscitated, they saved you, but you're hooked up to machines, you might be brain dead, do you want to remain on those machines? So they're two different documents. And then in addition to the Advanced Healthcare Directive, sometimes we will do the HIPAA Privacy Release form. The HIPAA Privacy Release form is for those people who want their agents to be able to talk to their physician, or their physician to be able to talk to their agents about their healthcare. So this is the example where maybe someone's able to take care of their dad, and their dad has good days and bad days, and on a bad day can't take his medicine. He doesn't know which medicine to take, and he can't communicate to you, and you don't know. And so you call his physician, and the physician says, oh, you're not my patient. Can you put your dad on the phone? I'll explain it to him. And he's like, well, he was able to have a conversation, he would have explained it to me. And so in that scenario, if that doctor, that physician had the HIPAA release form, and then if the child calls, the doctor can talk to the child about the parent's healthcare directly. And then the last document I've saved to the end because it is the most complex document. We spend the most time. The most common question that I get during my estate planning consultations is, what's the difference between a will and a trust, a revocable living trust, and do I need a trust? And so to be able to answer that question, I have to make sure you understand what a revocable living trust is. So here we have, not everyone inherently needs a revocable living trust. You need to have a purpose to create it. The trust has to have a type. Is it amendable? Is it not amendable? There has to be a trustee. The trustee is the person who controls what's in the trust. They carry out the terms of the trust. There are beneficiaries. Those are the people that sit back and just receive the checks in the mail. They benefit from the trust. And then there's the assets. You have to decide during your life whether you want to put something into your trust or not. And then when does the trust terminate? Usually that will be within the trust itself. It'll say when it terminates. So I'm going to break the trust down into two different columns. I'll show you that one. It's going to be afterlife, and now we're talking during life. So during life, let's focus on that. If you are setting up a revocable living trust, for today, we're going to refer to you as the grantor of that trust. So you set up this trust. It's a revocable trust. The trustee, you're usually the trustee of it. So the grantor is usually the trustee, and always the beneficiary. So there could be a time in your life where you set up a revocable living trust. So you're the grantor, you're the beneficiary, but you might not be the trustee, because you can resign as the trustee of your own trust. If you're having a hard time writing checks, going to the bank, managing your affairs, you could proactively resign, or you could be deemed incapacitated. And you can define in your trust what triggers the incapacitated. And so in a lot of documents, it's if two physicians agree you lack the capacity required to perform the duties of a trustee, then you can be removed. So if you're living, but you've resigned, or you're deemed incapacitated pursuant to the terms of your trust, you are still living, so you're the beneficiary, but you're no longer the trustee of your trust. So the successor trustee, whoever you've appointed in your trust as the person to take over, can take over during your lifetime. And so they manage whatever's in the trust for your benefit as the grantor, because as long as you're living, you're the beneficiary of whatever's in your trust. And that is what we refer to as the incapacity planning element of a trust. So earlier I explained the power of attorney, where that's the document that appoints someone who can help you during your life. One of the disadvantages of a power of attorney is that the institution that you're trying to present the power of attorney to act on behalf of, let's say, your dad, they could say, no, we don't accept that document because it's executed too long time ago, or the wrong form, or the wrong name, or maybe their policy is they just don't accept power of attorney documents because they've been misused in the past. The power of attorney is not legally enforceable, as opposed to if there's a revocable living trust, it's a trust account, the successor trustee would just prove like, okay, the grantor has resigned or they're deemed incapacitated, and they accept, saying, I accept my role as the new trustee because the grantor is no longer the trustee, and they become the trustee and they have the authority to manage whatever is in the trust. So it's a much more structured approach than trying to rely on the power of attorney document that's not always accepted. And then the next thing on the list are the assets. When you create, the first step is to create a revocable living trust. And then the rest of your life, that revocable living trust is kind of just like a bucket that you can carry around the rest of your life, or sometimes now the new age, it's the cloud that just kind of floats above you. And so you can put things into it or take things out of it at any time the rest of your life. And so you have to decide, with help, what assets you should transfer into your trust, and then what assets you can't transfer into your trust, or you should or should not, based on different reasons. And so we help people set up estate plans with revocable living trusts, and then we also help them figure out how to fund them. But usually the funding part, unless it's real estate, we do deeds and we help fund real estate in the state of Hawaii into our clients' trusts. But like bank accounts, for example, you would actually take your trust once you create it to the financial institution of your choice and show them the trust while you are setting up an account with them. And so from that point on, that account says your name, comma, trustee. And so that means that that account is in your trust. So in the event of incapacity, your successor trustee, if they step in as the new trustee, have total access to that account. And so you usually want to transfer your real estate generally into your trust, because that would trigger probate if it is not in your trust. And then major financial accounts, not retirement accounts. Retirement accounts have to stay in your individual name. And then when does it terminate? So during your lifetime, you can terminate that revocable living trust anytime you want. You can amend it anytime you want. Revocable means it's basically amendable, and you can do anything you want with it during your lifetime. So when you're the grantor of a revocable living trust and you have capacity, it's really just a disregarded entity. There's no real difference in terms of how you enjoy and control the asset during your lifetime when something is in your revocable living trust versus in your individual name. The revocable living trust is basically a disregarded entity. The accounts use your social security number. The IRS doesn't even know you have a trust. You still report all your income the exact same way you did before you had a trust. The main difference when you put something into your trust is how that asset is managed in the event of your incapacity or death. It makes it easier for that next person in line, in this case, the successor trustee, to step into your shoes and help you in the event of incapacity or death. So that transitional period is easier when you hold something in a trust. So that's how a trust works during your lifetime. The main purpose, the main benefit, other than giving you peace of mind that your wishes will be carried out after your lifetime, is that incapacity planning that could benefit you while you're still living but unable to manage your own affairs. And then after your lifetime, it's a very different thing. So upon your death, if the grantor is not living or if the grantor is incapacitated, the trust becomes irrevocable because no one can change the revocable living trust other than the grantor. So grantor is now deceased, so the trust becomes irrevocable. Even if it's still called a revocable living trust, it's no longer revocable. And then the successor trustee steps into their role as the acting trustee by signing an acceptance. So that's one of the main differences between a will and a trust, is that process of how the successor trustee steps in to become the acting trustee when the grantor dies. So as I was explaining earlier, when someone dies owning real estate, it triggers probate if they have a will or no will. The real estate's just in their name. But let's say that person created a revocable living trust and it's the property is in the revocable living trust when they die. So the child calls my office and says, Dad just died. He had a revocable living trust. He has one. His property's in it. His other assets don't trigger probate. And so probate's not triggered. Instead of going through that probate process where we put together the application and send it off to the courthouse, we will just have the successor trustee sign a paragraph that says, I accept my role as the new trustee because the grantor is no longer living. And they become the trustee and they can manage whatever's in the trust without having to ask permission from any outside party like the state of Hawaii. So that's one of the main differences, is the probate avoidance. Another is the incapacity planning that I explained earlier. And then who are the beneficiaries of your trust? That's whatever the trust says. So a lot of times people call me and they say, oh, my dad, my mom died and they had a trust. What happens now? I'm like, well, you have to read the trust. The trust will say what happens when the grantor dies. And so every trust is different. Every administration is different. We just have to make sure the trust is followed. And then the assets that are in the trust, those are easy to get to by the new acting trustee. The assets that are not in the trust because you decided not to put them in the trust for whatever reason, maybe you didn't get to it, maybe there's purposeful, the will pours them over into the trust. So everything eventually gets to the trust and the trust says who the beneficiaries are. And then it terminates when the grantor decides they want the trust to terminate. So I'll explain different scenarios. Basically, the purpose of having a trust, other than incapacity planning and probate avoidance, is the ability to control from the grave, control your legacy. And so I'm going to talk about a few different popular scenarios that I see why people want to control from the grave. Because something is important to them that they want to make sure is followed after their lifetime. So in a will, you can say, I want this person to be a beneficiary of this. I want this person to get this percentage. I want this person to get this dollar amount. You can break up different beneficiaries in a will. But as soon as you say, I want my child to get X amount of dollars or 25%, but I want them to have to use it for education, for example, then you need a trust for that. You can't have any provisions with contingencies in a will. The trust is needed to have sort of contingencies upon how an inheritance should be used. Because we call beneficiaries for a reason. You want whatever you're leaving them to benefit them, not to hurt them. And so if you think that a lump sum distribution or property distribution outright to someone would hurt them because they're too young or they're addicted to drugs or gambling, then you don't want to do that. So you can create a trust that benefits them, but they don't have total control over. So the scenarios where I see that most common, and it's right here on the slide, is mixed families. So that's you're married, second marriage, and you both have children from previous relationships, and you've been living together for a long time in one home that is owned by one spouse because they had it before they got together. So when that one spouse dies that owns the home, if they say, okay, I want my current spouse to be able to live in this house for the rest of their life, but if they move out or if they sell it, they want to sell it, then the trust terminates and it goes to the kids of the deceased spouse. So it doesn't give the opportunity of the surviving spouse to disinherit the deceased spouse's children. So that's one scenario that I see common. Another scenario is if there are young beneficiaries. So I remember I explained in the will, you can name the guardian of your children, and you can also leave your children as the beneficiaries of whatever you own when you die. But if you do it in a will, that child, when they attain the age of 21, have total control over whatever is left and wasn't used for by their guardian to raise them. So if you are concerned about a 21-year-old inheriting full control, having full control over their inheritance at that age, then you would need a trust. And in a trust, you can say, I want the trustee, maybe it's auntie, uncle, family friend, to use the money for my child's health, education, maintenance, and support until my child's 25 or 30 or 35 or their entire life if they're never going to be able to manage their own affairs. So if that is the case, the trust would terminate when that child attains that age, and whatever is not used for their health, education, maintenance, and support up until then, the remaining balance gets distributed to them outright when they're older and hopefully more mature at that time. And then maybe what if one of your beneficiaries that you want to leave something to is a special needs individual and they're receiving Medicaid benefits. And so if they inherit anything from you, they will be disqualified from those needs-based Medicaid benefits. And so you could still leave them their share of inheritance, your estate, but you can say their share stays in a special needs trust, which means the funds would be used to supplement the benefits they're receiving from the state or federal government, but not disqualify them from receiving those benefits. Because if you disqualify them, then they may be displaced and then they spend down their inheritance and they have to reapply. So it could disturb their lifestyle. So those are the kind of main reasons I see people controlling from the grave. There's really a trust is a contract and you can say anything you want to say in a trust. So my responsibility as a estate planning attorney is to help people navigate the options and make sure the trust can be followed, is understood by everyone, and doesn't create additional drama unnecessarily after your lifetime. And then we went over probate avoidance, tax planning. So everyone always asks about estate tax, death tax, inheritance tax, whatever you want to call it. It's called estate tax. That gets triggered. Right now, the rules are always changing, but right now, the state of Hawaii requires a deceased person, the estate, to pay a tax if that person dies with enough wealth. So right now, the estate tax exclusion, which is the amount that you can have at your death without worrying about paying any estate tax is in the state of Hawaii about 6 million, about 5.5 million. And so that, if you have less than that amount, then you don't have to worry about tax planning. And so if you're married, it's twice that because each spouse has that amount. So for married couples, it's about 11 to 12 million before you have to worry about estate tax. And so a lot of people don't have to worry about estate tax. But if you do, then you can incorporate tax planning into the revocable living trust as well. Probate avoidance, we talked about how revocable living trust can avoid probate if it's properly funded during the grantor's lifetime. And then asset protection. I have to really emphasize that it's asset protection for the beneficiary after the grantor's lifetime. The grantor who sets up the trust, a revocable living trust, does not get any asset protection because the grantor has total control over the trust. They're the beneficiary. They can do whatever they want. And it's a disregarded entity. And so there's no asset protection. The assets in your trust are viewed basically the same as assets in your individual name. But if you have a beneficiary, like a child who has a creditor, who has a lifestyle that you're scared that they may have a creditor in the future, you can, if you leave their inheritance in a trust for their benefit with certain terms, it would provide them with asset protection so that if they have creditors, their creditors cannot get to their inheritance that's in trust for their benefit. Because the trust isn't used to pay their creditors, it's only used for their health, education, maintenance, and support. And so since I've just been spending a lot of time talking about revocable living trust, I just thought I'd real quickly mention what an irrevocable trust or irrevocable trust. And it's not as common. When someone says they have a trust, 9 out of 10 times, if they're talking about estate planning, they're talking about a revocable living trust. But there are different irrevocable trusts that you can set up for various purposes. One purpose is asset protection. So if you are primarily concerned about asset protection, there are trusts, irrevocable ones that you can set up that are like business entities that are separate from you. They have their own tax ID number, they file their own separate tax return. And when you put assets into it, it's basically like a gift because you're giving the assets away to this irrevocable trust. And then there is some distance between you and those assets. And so there is some asset protection provided in that scenario, but you definitely want to make sure that you know what you're doing. You're well advised before setting something up like that, because once you do it, it's irrevocable, so you can't amend it, and the trust will control what's in what you put into it. So a lot of times people don't put assets that they need to live on. They put assets, maybe like a nest egg that they have on the side that they never really might need to use, but could benefit them. And then tax planning, charitable giving, incapacity planning. So if someone's worried about that their trust may be changed in the future by them because they get tricked or something, they may want to set up an irrevocable trust so that they can never change it. I don't personally like setting up irrevocable trusts for people because things change and I like flexibility and control, but people have various purposes and they can set up irrevocable trusts if one of those goals require it. And then talk about incapacity planning, because I bolded and underlined it in that first slide. We have this slide that explains how these different things, power of attorney, signatory, joint ownership, and trust work for incapacity planning while you're living, but somebody is helping you manage your own affairs. I have these types of conversations all the time. And so some people will just rely on the power of attorney document. And you can make it effective immediately, which I like, or you can make it effective when a doctor says that you don't have capacity. Is it legally enforceable? No. Are the assets that it controls frozen upon death? Yes. Power of attorney is only valid during the person's lifetime. So sometimes people come in and say, oh, my mom just died, but I'm the power of attorney, so I need to do this, 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 and this now for her. And I'm like, well, let me take that power of attorney from you because your mom's no longer living and I can just shred it because it does nothing now. It only helps during her lifetime. So if you were accessing something with that power of attorney, you can no longer access it. And then the will or the trust would control where the asset goes, and with that asset that you were trying to have control over with the power of attorney, be part of a probatable estate? And the answer is yes. And then sometimes people will sign up as a signatory for an account as opposed to a joint owner. So a joint owner is where you sign. So a parent sometimes will put one of their children on as a joint owner. I was explaining how that works earlier with the rights of survivorship. And sometimes instead of becoming a joint owner, they'll instead just make their child a signatory. So they're two very different things. And when I meet with people, sometimes they don't even know the difference, whether it's a signatory or a joint ownership. And I'm like, well, it's a signatory if your name's somewhere on the bottom saying you have authority to sign on your mom or dad's behalf. It's a joint ownership if above the address that has both of your names, then it's a joint ownership. So you can usually tell that way. But if you're not sure, you should check with the financial institution because they're treated very different. The signatory, once you sign someone up as a signatory of your financial account, they have the ability to write checks immediately. Is it legally enforceable? Yes. Is that account frozen upon death? Yes, because the signatory's access only works as long as the account owner is alive. And then the account would go pursuant to the will or trust and potentially trigger probate. As opposed to a joint ownership, as I explained earlier, that has rights of survivorship. So if you're on joint with your parent and then they die, that account is not frozen. That account is now technically, through rights of survivorship, owned by that surviving joint owner, and does not get controlled by the will or trust. It gets controlled by rights of survivorship. And then there's the trust final row at the bottom that says, when does it become effective? And so in the trust, it defines incapacity. The trustee could resign, be deemed incapacitated, and then the new trustee would step in at that point. It's legally enforceable. Is the account frozen upon death? No, because the trust hasn't died. There's just a new trustee in place. And then the trust controls where the funds go after your lifetime, not rights of survivorship. And then it does not get included in a potential probate estate. I have a couple, so we have like 5 more minutes. I have a couple questions here. Someone said, oh, 21, how about 18? Yeah, so in the state of Hawaii, the Uniform Transfer to Minors Act allow you to control funds for a minor until age 21. If you want to relinquish control at 18, that's fine, but you can maintain control until 21. And then beneficiaries in Canada. So there are different international rules and that should be followed and should know about before naming international beneficiaries or trustees in your estate plan. Okay, those are the questions. So I'll just kind of quickly go through the next couple slides. In terms of who we help in our firm, we help young families who are worried about who's the guardian of their children, or if their children inherit too much at too young of an age. Business owners who are worried about succession planning. If they're not around, who's going to write checks? How is their business going to continue? Multi-generational families, the Big Islands, people own real big plots of land with lots of owners. And so estate planning can help minimize the conflict among the different family members and generations who own the same assets. Kapuna, who are mostly concerned about incapacity planning and avoiding probate. And then people who've created estate plans outside the state of Hawaii on the mainland and then have since moved here. It's always a good idea to review your estate plan with an attorney in the state where you currently reside. So we do a lot of reviewing of estate plans that were created on the mainland, and then I give my advice on whether they need to update it and how. And then, as I have said several times, life changes, and so your plan should always be reviewed and updated. If it gives you peace of mind now, that's great, but that peace of mind kind of fades over time. And eventually, if you don't have peace of mind that your estate plan carries out your current set of goals, it's time to review it, at least review it. And sometimes just the reviewing process gives you peace of mind that it is current, and other times it will require an update to keep current. A good rule of thumb is every 4 or 5 years to at least review your estate plan, maybe do a new power of attorney healthcare directive, because those documents are harder to use if they're older than 5 years. And then if there's just a new significant life event, a new family member, one less family member, a change in legal relationships. One I like to point out, because people don't think about it, is if you're caregiving for someone who's older than you, you think everyone's going to die in the correct order. But what if you, as the caretaker of an adult, die before that person? You can incorporate into your estate plan that your funds would be used to help take care of that person, because that does happen. If everyone died in the same order, that would be great, but people die out of order all the time, unfortunately. Okay, so we have a few minutes. If you have any questions, that would be, you can ask them now. You can type them to me. You can unmute your video. Otherwise, if you press the button chat, and you scroll to the top. Actually, no, I'll just write it right now to everyone. I'm going to paste this evaluation link. So if you just go to the chat, press this evaluation link, it'll take you to my website where you can just fill out a brief feedback, because I do these presentations a lot. I like getting feedback. And you can also, if you wanted to set up a meeting, write down your contact information and just follow the evaluation sheet. And I can answer any questions you have after through email or phone call or Zoom or in-person meeting. Okay, so doesn't look like anyone has any questions. I can just hang out. Oh, so can I choose more than one trustee? Yes. So you can have co-trustees during your life. If it's your separate trust, you're usually the only trustee. If it's a joint trust with a spouse, for example, usually spouses are co-trustees. And then after your lifetime, if you have 2 children or something, and you can't decide which one, you can name them both as co-trustee. I like when there's one trustee, but sometimes it's hard to pick one person, and 2 is better given the situation, and that's totally possible. You just have to make sure that they both sign the document. So the advantage is they both have to sign, so they hold each other accountable. The disadvantage is that they both have to sign, so it's just more paperwork for them. And then does the will be the same as trust? And so when you have a trust, you also have a will, and the will is called a pour over will. So the will is always part of a comprehensive estate plan. It's whether or not you want to include a revocable living trust in addition to the will. And the will, usually the personal representative will match the same lineup as the trustee in the trust. So the personal representative and the trustee, their responsibilities kind of overlap. And if it's the same order, it's a lot easier for them to carry out your wishes and get things done. All right, I'm going to stop sharing. And we have one more question. We have no kids and only have 2 nephews who are Canadian living in Vancouver. Yeah, if your beneficiaries are in a different country, you're living here, you want to control your estate plan, yes, I can help with that plan. Sometimes people ask if they have assets in another country. Those assets would be controlled by the laws of that country. And so you'd want to consult with a professional in that country regarding that piece of real estate that is outside the United States. But if your United States is here, if your property is in the United States, you can hold it in your revocable living trust if you have one. I am in Waimea and Kona, and I go to Oahu and Maui. The other attorney, Kumu Belcher, is in our Hilo office. So they just asked about our Hilo office. And you would like Kumu Belcher. All right, great. So that's it for now. Thank you to the Hawaii Community Federal Credit Union for having this community educational webinar. And I'll be signing off